The court's order, of course, was to deliver to the court the originals of all subpoenaed items, as well as an index and an analysis of those items, together with tape copies of those portions of the subpoena recordings for which transcripts had been released to the public by the President on April the 30th. Now, this case presents for review the action of the lower court. Now, may I, before I get to the jurisdictional points, briefly state what we consider to be a bird's-eye view of this case. Now enmeshed in almost 500 pages of briefs, when boiled down, this case really presents one fundamental issue. Who is to be the arbiter of what the Constitution says? Basically, this is not a novel question, although the factual situation involved is, of course, unprecedented. There are corollary questions, to be sure. But in the end, after the rounds have been made, we return to face these glaring facts that I want to briefly review for the final answer. In refusing to produce the evidence sought by subpoena duces tecum in the criminal trial of 7 defendants, among them former chief aides and devotees, the President invokes the provisions of the Constitution. His counsel's brief is replete with references to the Constitution as justifying his position. And in his public statements, as we all know, the President has embraced the Constitution as offering him support for his refusal to supply the subpoenaed tapes. Now, the President may be right in how he reads the Constitution, but he may also be wrong. And if he is wrong, who is there to tell him so? And if there is no one, then the President, of course, is free to pursue his course of erroneous interpretations. What then becomes of our constitutional form of government? So when counsel for the President in his brief states that this case goes to the heart of our basic constitutional system, we agree. Because in our view, this nation's constitutional form of government is in serious jeopardy if the President, any President, is to say that the Constitution means what he says it does, and that there is no one, not even this Supreme Court, to tell him otherwise.
Mr. Jaworski,
yes,
the President went to a court. He went to the district court with his motion to quash, and then he filed a cross petition here. He's not, he's asking the court to say that his position is correct as a matter of law. Is he not?
He's saying his position is correct because he interprets the Constitution that way.
Correct, and he's submitting his position to the court and asking us to agree with it. He went first to the district court, and he's petitioned in this court. He's not. He has himself invoked the judicial process, and he is...
Well, that's not entirely correct, Mr. Justice.
Well, didn't he file a motion to quash the subpoenas in the district court of the United States?
Sir, he has also taken a position that we have no standing in this court to have this issue heard.
As a matter of law, he's asking he's making that argument to a court.
So that
as a matter of constitutional law, he is correct.
So that, of course, this court could then not pass upon the constitutional question of how he interprets the Constitution if his position were correct that I had...
As a matter of law, if his position is correct,
right,
then he is the sole judge.
That's right.
And he's asking this court to agree with that proposition as a matter of constitutional law.
But what I'm saying is if he is the sole judge, and if he's to be considered the sole judge, and he is an error in his interpretation, then he goes on being an error in his interpretation.
Well, then this court will tell him so. That's what this case is about, isn't it?
Well, that's what I think the case is about, yes, sir.
He's submitting himself to the judicial process in the same sense that you are. Is that not so, Mr. Jaworski?
I can't see
You take one position and he takes another.
Well, Mr. Chief Justice, in my view, frankly, it is a position where he says the Constitution says this, and nobody is going to tell me what the Constitution says, because up to this point, Up to this point, he says that he and he alone is the proper one to interpret the Constitution. Now, there's no way to escape that because the briefs definitely point that out time after time.
I think this matter may be one of semantics. Each of you is taking a different position on the basic question, and each of you is submitting for decision to this court.
Well, we start
Maybe, sir.
We start with a Constitution that does not contain the words executive privilege. Is that right?
That's right, sir.
So why don't we go on from there?
All right, sir.